Welcome, everyone. My name is John Sturtz, and I'm Professor of Education and Holocaust and Genocide Studies at Keene State College, as well as the Program Implementation Consultant for the Cohen Institute. This year, I'm helping to implement many of the offerings associated with the Institute's new research division. Today's program is part of the Institute's series of critical response events. These events are meant to promote understanding and conversation about emerging and ongoing crises and critical topics throughout the world. Today, we'll be focusing our attention on the cases before the International Criminal Court. The goal for this series is to promote a wide range of viewpoints and expertise. The views and opinions expressed by guest speakers are those of the individual and do not necessarily reflect or represent the views or positions of Keene State College, the Cohen Institute, facilitators, and/or other participants. Our format for today's lunchtime discussion will be as follows. We will have about 30 minutes of presentation and discussion by our guests, followed by about 10 minutes available for questions before we wrap up. Audience members may submit questions to the moderator using the Q&A function in Zoom. We ask that individuals wishing to suggest questions, please frame their inquiries in a respectful and open-minded manner. We welcome questions that highlight intellectual rigor, curiosity, and common courtesy. We may need to reword questions at times for clarity, and we may not be able to answer every question posed in the chat. I would also like to remind everyone that unauthorized video, audio, and other recordings of today's events are prohibited. The facilitator for today's event is Dr. Phil Barker, Professor of Political Science at Keene State College and Cohen Institute Specialist for 2025-2026. I will now turn the floor over to Dr. Barker, who will introduce today's presenter and facilitate the conversation.
Good afternoon, everyone. Welcome. I'm Phil Barker. As John said, I'm Professor of Political Science, Director of the Morris August Honors Program here at Keene State, and a Cohen Institute Specialist. And I have the pleasure of moderating today's conversation hosted by the Cohen Institute. We're glad you're here. I think this will be an interesting discussion about one of the more important, I think often overlooked, often controversial institutions in global politics, which is the International Criminal Court. So the ICC has been making headlines in recent years, more so than normally, I think, mostly around the issuing of arrest warrants for figures like Vladimir Putin in 2023, Benjamin Netanyahu in 2024. Those moments remind us just how complex the idea of international justice can be. They're also really nice illustrations of how the court works and what its limitations are. And so we're going to get into when does a case rise to the level of genocide versus a crime against humanity? We can get into questions about how the court functions and what sorts of evidence it looks at, what gives the court its authority, what limits that authority, especially when powerful nations like Russia and the United States and Israel are involved. So to help us explore all these questions, we are fortunate to be joined by Mariana Salazar, a leading international lawyer and scholar with more than 20 years of experience in international criminal law, human rights, and atrocity prevention. She served in high-level roles with the United Nations, the Organization of American States. She currently teaches in Madrid and Mexico City as well, I think. Are you still teaching there, right? While contributing to the International Review of the Red Cross, the Mexican Council on Foreign Relations. Incredibly accomplished, and she brings an extraordinary expertise and firsthand insight into how international law actually operates, not just in theory, but in the real world. And we are delighted and lucky to have her here. So as John mentioned, the two of us are going to have a conversation, and then we will turn to questions at the end. But welcome, Mariana. Thank you for taking time out of your schedule to join us here. I think you and I had talked about, I think that what makes sense is to just kind of start with the basics. Do you want to walk us through what the International Criminal Court is? What does it do in the context of international justice? And then we can sort of take our conversation from there.
Absolutely, Phil. And thank you, Phil. Thank you, John. And thank you to the Cohen Institute for Holocaust and Genocide Studies at Keene State College for the invitation to join you to discuss this very relevant topic in our current global landscape. So the International Criminal Court is the first and only permanent international criminal tribunal, and I underline the word permanent, in charge of investigating and trying persons accused of committing the most serious crimes of international concern. So it came about as the culmination of decades of evolution of the branch that we call international criminal law. This branch that was born after World War II with the Nuremberg Tribunal in 1945, which was in fact the first ad hoc special international criminal tribunal. It was the first time that individuals were criminally prosecuted before an international court for crimes. Before that, before the existence of international criminal law, all crimes were prosecuted in national tribunals. But the common understanding after the World War was that there are some crimes that are so serious that their investigation should not remain the sole arbitrary decision of one state, right? So that there is an international concern for their being investigated and being punished. So this is why international criminal law was born. This, as I mentioned, the ICC was the culmination of the evolution of international criminal law, which started with the Nuremberg Tribunal in 1945. It was followed by the International Military Tribunal for the Far East in 1946, the Tokyo Tribunal. And then after around 50 years of not advancing in the creation of any new international criminal courts, then came the decade of the 1990s. And we saw a second phase in the evolution of international criminal law with the creation of the International Criminal Tribunal for the former Yugoslavia, the ICTY, in 1993. And 1 year later, the creation of the International Criminal Tribunal for Rwanda in 1994, right after the genocide in Rwanda. So these two were ad hoc, meaning they were created for specific situations. They were created by the UN Security Council at that time, precisely because albeit the fact that there had already been the idea of having an international criminal court when the Nuremberg trial in 1946 finished, there was already the idea of creating a permanent international criminal tribunal. But although the International Law Commission of the UN was mandated with a draft statute, and they actually prepared a draft statute for a permanent international criminal court, the Cold War and other considerations stalled any advancements on these topics. And then, of course, in the 90s, when the UN saw itself obliged to create the special ad hoc tribunals for Yugoslavia and Rwanda, of course, the discussion reemerged. And so the decision was to reignite the process to create a permanent international criminal tribunal. So this was done, and based on a draft prepared by the International Law Commission and adopted and approved by states, that draft was actually the basis of the Rome Conference, the conference that negotiated in 1998 the Rome Statute that gave rise to the International Criminal Court, that created the International Criminal Court. So it's important to mention that while the draft was written by the UN, the first draft of negotiations, these negotiations actually took place outside of the UN, because the International Criminal Court, as it stands today, is not an organ of the UN, of the United Nations. It stands alone, it stands independently, but it does have, of course, a collaboration agreement with the UN. So the Rome Statute of the ICC, or International Criminal Court, came into force in 2002. The jurisdiction of the International Criminal Court is for crimes which have been considered by in this history of international criminal law as the most serious crimes of international concern. These crimes for which the states are willing and were willing to give up their own, exclusive jurisdiction over them, because they are crimes so serious that it is understood that no matter where they are committed, they affect humanity as a whole. So these crimes are genocide, war crimes, crimes against humanity, and the crime of aggression. This is the material jurisdiction of the International Criminal Court today. So I will share a few statistics on where the court stands currently. So the court is based in The Hague in the Netherlands. And as you can see in the slide I am sharing, this Rome Statute currently has 125 states parties. This number, unfortunately, has not been steadily increasing in the last years. on the contrary, we have some news of recent withdrawals from this statute, which might bring the number down to 121 for 2026. The court has, as for its structure, it has an office of the prosecutor in charge of investigating and prosecuting, gathering evidence to see if and whether there appear to be crimes, jurisdiction of the court being committed in a state. And of course, if there appears to be no investigations or prosecutions going on nationally. And I say this because the International Criminal Court works on the basis of the principle of complementarity. It is only competent when the state is unable or unwilling to prosecute. So the Office of the Prosecutor gathers in what is called a preliminary examination. It gathers the evidence necessary to determine whether there appears to be these crimes and whether there appears to be jurisdiction by the ICC because the state is unwilling or unable to investigate or prosecute. Besides from the Office of the Prosecutor, there is the Judicial Division, which is composed of 18 judges elected by the Assembly of States Parties of the court. And these judges, in a pretrial stage, in the pretrial chamber, they receive the prosecutor's request to open investigations normally in some of the ways of referring situations to the court. They issue arrest warrants or summons to appear. They can handle the confirmation of charges hearings. And then the trial goes on in the trial stage and then in the appeal stage, of course. So there is the trials that go on at the ICC, at the Hague's headquarters, and these trials only take place when the person is physically there. So there are not trials in absentia. Currently, in this judicial investigation phase, we can see that the ICC is handling 12 ongoing judicial investigations in the Democratic Republic of Congo for situations in these countries, in the Democratic Republic of Congo, in Darfur, Sudan, in Libya, in Côte d'Ivoire, Mali, Burundi, in Bangladesh, having to do with Myanmar displaced Rohingya persons, Afghanistan, Palestine, Philippines, Venezuela, and Ukraine. There have been some investigations concluded already in the past, 5 of them, and in the preliminary examination phase, which is this earlier phase conducted by the prosecutor, there are currently 3 preliminary examinations going on: Nigeria, another one on Venezuela, and the situation of Lithuania, Belarus. So in total, as I mentioned, the court has existed since 2002. In total, there have been 69 persons subject to arrest warrants or orders or summons to appear by the International Criminal Court. There have been, of course, procedures and proceedings taking place, but there are still 30 defendants that are at large. The fact that they are at large does not mean in all cases that we do not know where they are. It means that they have not been arrested, and I'll speak to this further on in our conversation. Currently, there are 6 persons in custody in the court, and in these more than 20 years of existence, there are 6 persons that have been formally convicted and in a final already confirmed stage, convicted for international crimes. 6 persons for these crimes, only for war crimes and crimes against humanity in the situations of the Democratic Republic of Congo, Mali, and Uganda. There's another case where 5 people were convicted for offenses against the administration of justice, which has already been concluded as well. And there are recent convictions which are still subject to confirmation or appeal. And these recent convictions have to do with the situations in Central African Republic and in Darfur. And I'll leave it at that just to open for the conversation.
Yeah. So I mean, I think this the background is perfect, and it it gets at it is a really complicated institution, particularly when you start getting into the issues of jurisdiction and both subject matter jurisdiction, but location, like what territorial jurisdiction they have. Let's turn to the two kind of prominent cases out there. Let's talk a little bit about the Vladimir Putin and the Benjamin Netanyahu cases. They were not the only ones who had arrest warrants issued in those particular cases, but they're the two that people are most familiar with. Both of those cases, I think, illustrate a bit about the types of crimes that the court looks at, but also some of the kind of political limitations of the court. So maybe we just begin. Do you want to talk a little bit about the sort of background of the cases, what sorts of charges have been brought, and maybe why others? We can talk a little bit about why genocide is not one of those charges as we move through. I'll just kind of let you approach that how you want here.
Absolutely. So with the state of Palestine, this is a very interesting case because Palestine had been attempted to refer its situation. And as an introduction, there are three ways in which situations can arrive to the cognizance of the court, right? So first of all, it can be a state that refers its own or another state situation, a state that is party to the Rome Statute, or a state that has deposited a special declaration saying that it accepts the court's jurisdiction for a specific time frame regarding its territory or people of its nationality. So first, again, the referral by a state that is a party or that accepts the court's jurisdiction. That is the first way in which the court can receive a situation. The second way is where the United Nations Security Council refers a situation to the ICC. This is interesting in cases where the state is not a party to the Rome Statute. So the ICC has, in fact, in the past referred two situations to the Security Council has, in fact, referred two situations to the ICC. The first one in 2005, Darfur, Sudan, and the second one in 2011, the situation in Libya, both regarding states that are not party to the Rome Statute. The third way in which the ICC can commence a preliminary examination on a situation is if the prosecutor himself starts on its own. The Office of the Prosecutor starts an investigation, what we call a motu proprio preliminary examination. So it does it on its own. But it can only do that if the state is the state in which the territory of the crimes is involved, or if the national state of the people that are, the perpetrators are states parties to the Rome Statute. So there is this principle of territoriality or of active personality in criminal terms. That means that both for state referrals and for prosecutor motu proprio preliminary examinations, there has to be a nexus. The state party has to be the state of the territory where the crimes are being committed, or the state of nationality of the perpetrators or alleged perpetrators. And this it complicates things a little bit. So in the case of Palestine had been trying to refer its situation to the ICC for a long time. And the ICC, in the time of the first prosecutor, Luis Moreno Campo, was in a interesting position because the prosecutor replied to Palestine saying, I see in the Rome Statute that only states can refer their situations. And I, as an international criminal court, am not one to say if you are a state or not. So I cannot actually open this preliminary examination yet until you tell me or confirm to me that you are in fact a state confirmed by the UN. So this led to a very interesting process in terms of international law, where Palestine actually went to the United Nations. And in the United Nations, Palestine did not try to become a full-fledged member state of the UN, because that would have required the approval of the United Nations Security Council, where, of course, the U.S. stands, and U.S. is very close to Israel, and so it was unlikely that the state of Palestine would have been admitted as a fully fledged member state. But Palestine achieved a resolution in the General Assembly where there is no veto, no permanent members in the General Assembly have any special rights. So this resolution allowed Palestine the status of a non-member state, observer non-member state. So the magic word here was the word state. Because with that magic resolution, where the UN, a majority of states in the UN are recognizing that Palestine is a state, Palestine could in fact go back to its request to the International Criminal Court. It lodged a declaration in 2015 accepting the jurisdiction of the court, and eventually it actually even ratified the Rome Statute. So the situation was referred to the ICC by the state of Palestine ever since 2015. It referred the situation for crimes occurring since 2014. In 2018, it broadened this referral. Palestine broadened it so that this referral would have no end date. So eventually, the prosecutor opened a preliminary examination, this preliminary phase, and it did conclude in 2019. And by this time, it was Fatou Bensouda, the second prosecutor of the ICC from Gambia. She did conclude in December 2019 that the statutory criteria were met to request authorization to open a judicial investigation. However, as many of you are aware, there is this territorial question around the opening, and the former prosecutor had the same question. So what she did was she requested a ruling by the pretrial chamber asking the judges to clarify what the territorial scope of this examination would be. And the judges, in fact, issued their decision in February 2021, confirming that the territorial scope extends, of course, also to Gaza, to the West Bank, and to East Jerusalem. And that is what allowed then the official opening of the judicial investigation regarding the situation in Palestine. It was opened on 3 March 2021 with this territorial scope clarification done. So then we are, Karim Khan, the current prosecutor of the ICC, he took office in June 2021 when the investigation had already, recently been opened. And then, then all the proceedings, which I have described earlier, commenced. So warrants of arrest were in fact issued, and they were issued against the leader of Hamas, who referred to as Dave. In November 2024, the leader of Hamas was subject to a warrant of arrest, but as he died, the case had to be closed. And at the same time, warrants of arrest were issued against the Prime Minister of Israel, Benjamin Netanyahu, and against his Minister of Defense, Yoav Gallant. So this is indeed the situation in Palestine, the warrants of arrest. Just to be clear, before these 3 warrants of arrest were issued, 2 other requests by the prosecutor had been made to issue warrants of arrest against 2 other leaders of Hamas who were also then confirmed dead, and so the requests to issue warrants of arrest against them had to be withdrawn. So that's the situation of warrants of arrest regarding Palestine to date. And then regarding the Ukraine, again, same issue, because in the situation of Palestine, Israel is not a state party to the Rome Statute. In the situation of Ukraine, Russia is not a state party to the Rome Statute. And Ukraine, actually, just as Palestine did, Ukraine lodged a declaration accepting the jurisdiction of the court in 2014. It then broadened its declaration, the temporary scope of this acceptance of jurisdiction. And eventually, quite recently, Ukraine even became a party to the Rome Statute, right? So the preliminary examination regarding Ukraine was opened in 2014. It was in February 2022, right after the invasion, that the prosecutor concluded that the statutory criteria to request a judicial investigation was met, with the assistance of 43 other states who referred the situation right after the Russian invasion to the Ukraine. This accelerated the process because of a technical requirement that when a state refers a situation, you don't need to wait for an authorization by the pretrial chamber. So you skip a step, so it makes it quicker. So the investigation, in fact, was opened on March 2nd, 2022. And in this situation in Ukraine, as you mentioned, there are other warrants of arrest. Of course, the most heard of is the warrant of arrest against President Vladimir Putin. That warrant of arrest was issued in March 2023, together with another warrant of arrest against his Commissioner for Children's Rights, Maria Alexeyevna Lvova-Belova. And these are war crimes, are warrants of arrest for war crimes of unlawful deportation of population committed from at least 24 February 2022. Parenthesis, the arrest warrants issued regarding the situation in Palestine are also for war crimes and for crimes against humanity. Going back to the situation in the Ukraine, just to mention that another 4 warrants of arrest have been issued against commanders and chief general staffs of the armed forces, and against the Minister of Defense of Russia and the commander of the Black Sea Fleet.
So let me, you were mentioning the crimes that have been, the charges that have been brought in both of these cases. And I think when people think of the ICC, they often jump to the crime of genocide. And maybe this is a chance, just for a couple of moments here, that one of the things I think that people, I always try to emphasize to my students that there's an important distinction between sort of the political concept of genocide and the legal standard of genocide. So can you talk a little bit about why the court hasn't chosen to pursue genocide charges, or what some of the challenges are for bringing genocide charges in a case, in either of these cases?
This is a very important question, Phil, because the crime of genocide has a peculiarity regarding or vis-a-vis other international crimes. So it's characterized by the specific intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. There are 5 conducts that can amount to genocide, including killing the members of the group, causing serious bodily or mental harm to the members of the group, deliberately inflicting on the group conditions of life calculated to bring about their destruction, or imposing measures intended to prevent births within the group, or forcibly transferring children from the group to another group. However, and let me just mention one of the other international crimes, which is crimes against humanity. So crimes against humanity are serious violations committed as part of a large-scale attack against any civilian population. So when you think about crimes against humanity, you don't have this requirement of identifying the intent, the specific intent to destroy a specific type of group, right? And some of the conducts that are included in the 15 conducts that are crimes against humanity or amount to crimes against humanity are similar in the sense of killings, torture, sexual violence. Also, you have imprisonment, enforced disappearance, enslavement, apartheid, and deportation. At the same time, war crimes, which are the violations of the laws of war, also, all you have to prove in war crimes is that it is committed as part of an armed conflict. And some of the conducts in war crimes also include, for example, forcible transfer of population or intentional killing to civilians, etc. Why do I say this? Because from all the 4 international crimes, the crime of aggression is the use of armed force by one state to attempt against the sovereignty, integrity, or independence of another state. But why do I say all this? Because when choosing and when collecting evidence, the International Criminal Court's prosecutor will request arrest warrants at the beginning for the crime for which it has most solid evidence, right? So it's not surprising that the arrest warrants issued to this date do not include genocide in the reasons or the crimes for which these arrest warrants are issued. These arrest warrants against Netanyahu, against Putin, and against all these other people that I've mentioned, they are issued mostly for crimes against humanity or war crimes. It does not mean, however, that eventually these warrants can be additioned by an additional arrest warrant for genocide. This happens, and it has happened in the past. The ICC has issued arrest warrants for genocide, for example, against Omar al-Bashir, the president of Sudan, the former president of Sudan. The problem is that the ICC has to be conservative in the issuance of arrest warrants to make sure that they have the evidence needed to prove in a trial, in a judicial trial, to prove these conducts. Also, we have to bear in mind that in the International Court of Justice, there are cases that are being currently heard under the Genocide Convention. And so, without knowing, of course, it might make sense also to wait and see what the International Court of Justice decides on these genocide cases in order to then also decide or not to add genocide to the counts. It can decide not to wait. It's not mandatory. I don't want to confuse people, but of course it might make sense to wait and see what the ICJ says.
Great. So I'll just let me go ahead and say, if you have questions at this point, I'm going to start turning to some of the questions. So if you're one of our visitors and you have questions, please submit them to the Q&A, and we'll try to get to as many as we can. I see one question here that is asking about the legal implications when major powers refuse to recognize the ICC, and I think the U.S. has a very long history of not just refusing to recognize, but aggressively opposing the ICC. Obviously, Russia, Israel. What are the implications for that? But I think that also opens maybe we can talk a little bit about these arrest warrants have been issued for Vladimir Putin and Benjamin Netanyahu, and yet they're not arrested. They're still leading their countries. So maybe talk a little bit about where politics collides with the law here a little bit, and what it looks like, especially for major powers who are opposed to the ICC.
This is a very relevant matter. So as you know, the ICC is a judicial organ, and politics should not be involved or should not make a difference in the resolution of judicial cases, right? And this is actually the fact in how the ICC was designed and was created, and the way it works today. However, of course, first of all, there is a fact that the ICC does not have a police of its own that can go into a state and detain a person. So the ICC depends on the cooperation of states. Second of all, so the fact that there are some very powerful states that are against the ICC does not help the cause, because if the state support for the ICC is less, then of course we will be creating safe havens for these accused individuals to be able to just stay in those states without being detained, right? So that's the first thing. The second thing is the fact that the Security Council has a role also in being able to refer situations when states are not parties to the Rome Statute. So if you have, as is the case today, two very powerful permanent members of the Security Council with a veto power, you do see that some situations are not being referred by the Security Council to the ICC because of allegiances between these very powerful states, the United States, three very powerful states, the United States, Russia, and China, out of the 5 permanent members. So only France and the UK are actually states parties to the Rome Statute, and the other 3 permanent members of the Security Council are not. So this does have an implication in the vetoing of referrals of situations to the International Criminal Court. I can mention, for example, the situation in Syria. There was an attempt to refer it to the ICC, and it was not referred because of because of blockages by by these countries, for example. So there is also, and this is just one, of course, the situation of the Uyghurs in China and the situation of Russia, Ukraine, the situation in Palestine. These were not referred by the Security Council, and that is, of course, a big problem. And I also think so. First is the issue of cooperation in detaining and delivering a person to the court, and second, of course, is this issue of referrals by the Security Council. And then I think that also, in general, the legitimacy of the ICC is harmed by these double standards sometimes, because some of these very powerful states, we are seeing that depending on who is the person detained, they have one reaction or the other.
So to kind of build off of that, it can be easier. I even when I'm talking with students, oftentimes they very quickly then resort to this. It's all meaningless, right? But can you talk a little bit about like what are the implications? So the fact that an arrest warrant has been issued for Putin and Netanyahu, it is true that they're not under arrest, but does that, I mean, what power beyond sort of the legal power, what implications does it have to have a court, an international court like this, making a declaration of, that a crime has, in their estimate, happened?
So, first of all, I mean, the fact that they are subject to an arrest warrant by the International Criminal Court, according to the Rome Statute, if one of these individuals travels to a country that is a party to the Rome Statute, there is an obligation by that country to detain and deliver that person to the ICC. There's a whole debate around the matter of immunity of heads of state and whether their immunity would impede them to be detained because they are actually from states that have not waived this head of state immunity. In any case, these are so that's a whole debate that is going on right now. In any case, there is this obligation, at least by states that are states party to the Rome Statute, under the Rome Statute, at least to be able to cooperate with the court, right? This debate goes between Article 27 of the Rome Statute regarding the immunity, irrelevance of official capacity and irrelevance of immunity, which is the actual waiver by states parties, states that have accepted the Rome Statute jurisdiction, they waive the immunity of their heads of state by accepting this. But then there's another article, which is Article 98, which says that if you are in a situation where you are put in a situation which might actually lead you to breach customary international law of immunity of heads of state, which could occur with a state that is not party, like Israel or like, for example, Russia, then you are supposedly you can go through a consultation stage with the ICC, and there is, a possibility that your obligation to detain and surrender be questioned. The ICC has confirmed on numerous occasions regarding the al-Bashir case that in either case, even if it's a state that is not a state party to the Rome Statute, as was the case of al-Bashir in Sudan, in either case, any state would have the obligation to detain and surrender. But of course, there are some states that are questioning this. Politically, of course, there is a heavy burden if you're a head of state that is subject to an arrest warrant.
Yeah. There's a couple of just kind of more procedural type questions that I'll ask, clarifying how the court works. One of which is about how justices are appointed and how long they serve, and then another about whether or not the court only brings cases against individuals or if they can bring cases against groups, states, that sort of thing as well.
Thank you. So judges are appointed for 9-year terms, and they are elected by the Assembly of States Parties of the International Criminal Court. So this assembly is composed of the representatives of these today 125 states parties. That's 2/3 of the current global number of states in the world. And they are elected by a very complex procedure. There are 2 lists. There are some judges that are elected because of their judicial background and other judges that are elected because of their academic background. And these two lists, they are balanced, and also there is a balanced geographical representation. So elections try to make sure that all five groups of like-minded states, the European, Western European and others group, the Europe, Eastern European group, the Asian group, the African group, the Latin American and the Caribbean group, all these five regions are duly represented at a given time. They are elected for 9 years without a possibility of re-election. And regarding the other question, very important. So the ICC only investigates and tries individuals, not companies, not states. For states, you go to the ICJ. So the International Court of Justice, which is also in The Hague, that is the one responsible for dealing with controversies among states. For companies, you go to national jurisdiction. There are some states that are actually prosecuting, which is very interesting, even criminally, companies for international crimes such as genocide, war crimes, or crimes against humanity.
There's a couple of questions in here that sort of build off of, you had talked about, I think you even used the term legitimacy, the legitimacy of the court, challenges to the legitimacy of the court, particularly with the kind of uneven enforcement of justice across various states. So can you talk a little bit about what does legitimacy look like, and what do you see for the future? Like, what are the challenges to that? Like, if you look forward to the next kind of 10, 20 years of the International Criminal Court, what do you see as sort of the biggest challenges in establishing that international legitimacy?
It's a really tough question because how do you measure the success of prevention, right? Of course, here you have cases that are going on in the world, and it is very frustrating to see that some of the accused, many, like, I mentioned there are 30 people at large, right? 30 defendants at large in the ICC. But I think this is a problem with international law in general. I think that sometimes we see what is not working, but we don't actually see what is indeed, that the contribution it is indeed making. Something really important to understand is that because of the complementarity principle, the ICC has had a domino effect in strengthening some national jurisdictions. And I think this is a positive note. I think you can see more and more national jurisdictions understanding these types of serious crimes. We have cases before national jurisdictions of universal jurisdiction, for example. There was one this week, for example. So I think that there is this whole system effect that we cannot blind our eyes to the fact that the whole evolution of international criminal law has had an effect on strengthening universal jurisdiction and national jurisdictions. So even if the ICC does not have everybody in custody and has not tried all of its defendants, we can see it has had an effect. Of course, there are limitations, but there is, for example, right now we're seeing that the former president of the Philippines is being prosecuted. He's in custody and he's being prosecuted in the ICC. Just to cite one of the examples. So I think there are pros and there are cons. I do think that we do not or we should not cave into political discussions or pressures. The issue of international crimes is not a political issue. It's a legal issue. And so whether an international crime occurred or not is a matter of law. It's not a matter of politics. So if you have a legal instrument, I think we shouldn't cave into political delegitimization and try through all means possible for that crime to not be impugned and to actually be prosecuted, whichever place, either nationally, either in universal jurisdiction, either in a foreign court or internationally.
Great. This is what we're out of time. This has been fantastic. I could keep talking to you for hours about this. It's so fascinating. There's so many elements that we could dive into. But let me just, I guess I'll just wrap up by saying thank you so much for taking time out of your schedule to chat with us. It's so helpful. Your knowledge is so extensive, and it's been great having you. Thank you so much.
Thank you.
Thank you for a meaningful conversation today, and thank you to our guests for helping our audience think through some of these complex realities. As we wrap up, the Cohen Institute would like to welcome everyone to attend our other critical response events throughout the year. You can find more information about these events and other programs by visiting the Cohen Institute's homepage. Thank you, everyone, and have a great afternoon.